Welcome to Post-Roe abortion law in Alabama, a presentation put on jointly by the Medical Association of the State of Alabama and ProAssurance. My name is Brandy Boone. I'm the General Counsel of the Medical Association, also have history with ProAssurance, and we have Mallory Earley on, who is one of the regional managers in risk management for ProAssurance. Happy to have her with us. We have Julia Booth, who is the president of the Medical Association, who we plan to have introduce this program. And unfortunately, she's had an unavoidable conflict. So I'm just going to go ahead and start us. And I don't know why, for whatever reason, I'm seeing Amanda. Let me see if I can share my screen and get our slides up. Okay, I hope everybody can see the slides there, the post-Roe abortion law in Alabama slides. Just a few housekeeping details before we start. Number one, this program is not available currently for CME. We decided that the most important thing in putting this together was making sure that physicians in Alabama had the information they needed in order to know what was legal and what was not legal as far as abortion and any medical acts that can be defined as abortion in Alabama. And actually doing the CME would require either the Medical Association or ProAssurance to do that, and it usually takes a little bit more time. We are recording this, and you may see it as a CME activity either from the Medical Association or ProAssurance in the future. But also, as far as the information that we're providing for you tonight, this information is basically information that we know, laws that we know are in effect at this time as we're giving this presentation. Now, I don't expect anything to change in Alabama anytime soon, but I know that Mallory is going to talk about probably some other states and how they compare with Alabama's law. And those might be very fluid and they might change. So just letting you all know that we are at this point in time talking about law that is in effect in Alabama. Also, if you have questions, we want to hear your questions. I'm going to go through the slides in this portion of the presentation and go through the actual law called the Human Life Protection Act that is in effect in Alabama right now. Then I'm going to turn things over to Mallory, who has got some slides on some questions that ProAssurance has gotten regarding abortion and maybe some comparison as far as what's going on in other states. After we get through our material, we'll go through those questions and try to read those and answer those as best we can, whichever one of us is in the best position to answer the question. So please know that you can ask questions, but the way we have this webinar set up, it's best for you to type those questions out in the chat box or the Q&A, and we'll read them at the end of the presentation. All right. I also have some disclaimers that I have to go through. We recognize that abortion is a very politically charged issue, and it is an issue where there are passionate people on both sides of the debate. This program is meant to be educational in nature. It is meant to be about what the laws are in Alabama at this time. It is not meant to be a policy debate or a policy forum. We understand that people are very passionate about the issue, and we want your voices to be heard, but that's not what this particular webinar is about. We just want to talk about the law that is out there. So if you have questions about the law, we are happy to address those if we can. If you have questions about policy, this is not the event for that. So none of the presenters, myself or Mallory, will be answering questions regarding policy or position statements. All right, before we get into the actual law that's in effect in Alabama right now, I want to talk a little bit about how we got to that law, the history. Everybody's talking about post-Roe, Roe. Some people are calling it the Dobbs era now because that is the short name of the decision that just overturned Roe versus Wade. And there are a lot of probably misstatements and maybe shortened versions of how Roe came about that have been reported in the news. And most people are getting their news now from the internet or even worse, social media. It's an easy way for us to go to try to get our news. But when you try to take a very, very complicated political issue and put it into 140 character spaces on Twitter to explain it, sometimes things get shortened so much that they're a little bit harder to understand. So I wanted to give a very, very brief history of the Roe versus Wade decision and what it meant. Prior to Roe versus Wade, all of the states were able to legislate and basically enforce abortion laws however they wanted, whether they were restricting abortion or whether they were more liberal as far as whether or not abortions could be performed. Now, states still have that authority. They had that authority to manage those laws about abortion all the way through the Roe versus Wade era, even after that decision, because Supreme Courts are not there to legislate. They are there to determine whether or not state laws are constitutional. And if they are not constitutional, then those state laws in general can't be enforced. So Roe versus Wade came about because a woman in Texas ended up suing the state, claiming that their restrictive law that did not allow abortions except for a medical emergency was a violation of the Constitution. That case made it all the way to the Supreme Court, and the Supreme Court, in a 7-2 decision, decided that based on the due process clause of the 14th Amendment, that a restriction on abortion by a state was a violation of a fundamental substantive right to privacy that a woman seeking an abortion has. Now, that substantive right to privacy or fundamental right to privacy is not listed in the 14th Amendment. Supreme Court, let's say they took some license from other amendments to the Constitution and sort of put that privacy right together. And they said that this substantive right to an abortion, privacy right to an abortion, can trump a state's interest in restricting abortion to protect the life and health of the expectant mother and the fetus that she's carrying. So the state restrictions on abortion faced the highest standard based on this opinion that you can have, called strict scrutiny, which meant that it was very, very hard for a state to pass a law restricting abortion and that be constitutional. And the court also developed a trimester framework. And under that trimester framework, in the first trimester of a woman's pregnancy, an abortion was considered as safe or even safer than carrying the child. So very few state restrictions would be considered constitutional. Really about the only restriction that a state could put on a pregnancy in the first trimester was something like making sure that abortions are performed by a physician. In the second trimester, some restrictions might be allowed by the state, but they have to be narrowly tailored to protect the safety and the life of the pregnant woman. And then in the third trimester, that's when prohibition to protect the life of the health of the mother outweighed any kind of interest in that fundamental right to privacy. So states were allowed to put restrictions on within that third trimester. So that was the law of the land. And I say the law of the land because it was so hard for a state to restrict abortion in any way that's why you kind of hear stated in news reports where Roe versus Wade guaranteed a right to an abortion. Didn't guarantee a right to an abortion, but it made it very difficult for states to restrict an abortion. So about 20 years later, then you had a case out of Pennsylvania called Planned Parenthood versus Casey. In this case, the lawsuit was against Pennsylvania state government because they had a lot of restrictions on abortion. Some of those were consent restrictions, and the Supreme Court, which is a different makeup at this time, essentially decided we're going to uphold the primary holding of Roe versus Wade. We're going to still say that there is a fundamental right to privacy of a woman seeking an abortion. We're going to still say that in general, that's going to trump a state's rights in restricting abortion to protect the life and health of the mother. But because there have been advances in medicine, we're not going to use this trimester framework. We don't think that's accurate these days. Now we're going to say it's a viability analysis. And whether the state can restrict abortion depends on whether or not there's any evidence of the viability of the pregnancy. So Roe versus Wade essentially gets to stay the law of the land as far as it comes to abortion until 30 years later, or almost 30 years later, this summer, the Dobbs versus Jackson Women's Health Organization case came out. And I think most of us know that that was a case out of Mississippi. Mississippi's legislature had enacted what many refer to as a heartbeat law, essentially saying that there could be no abortions in Mississippi after there was a detectable heartbeat. What many would say, actually in Mississippi, I think they extended it to 15 weeks to try to get to a time frame where they felt like there could be viability, there could be a heartbeat. And that case went all the way to the Supreme Court. And that Supreme Court, which is the Supreme Court we have now, made the determination that, hey, that Supreme Court back in Roe versus Wade never should have come up with this fundamental right to privacy that was not in the Constitution, recognizing that there have been some important decisions not based specifically on abortion that also used something like a substantive due process claim. The Supreme Court said, we're only focusing on abortion in this decision. And in this decision, we're saying that that was wrongly decided and that abortion restrictions should be made by the state and that there's no constitutional or federal U.S. constitutional right to an abortion. States have the right to impose or not to impose restrictions. So that leads us to what Alabama's law is now. And I want to say before I get into that law that I know that in social media and online and news articles, there's been a lot of talk about trigger laws. And those laws are laws that states enacted that had a special provision. Maybe they restricted abortion, but there was a provision that said this law will go into effect at the point that Roe versus Wade is overturned or that fundamental right to privacy is considered no longer a fundamental right to privacy. Alabama's law is not a trigger law. Alabama's legislature enacted the current law, which is called the Human Life Protection Act, in 2019. So that was 3 years ago. And it's my understanding that the legislature intended the Human Life Protection Act to be the kind of law that could be taken up and challenged to possibly overturn Roe versus Wade. That didn't happen. It was federally enjoined as soon as it was enacted, so it was never enforced. But because that Roe versus Wade was overturned, the federal court overturned the injunction or lifted the injunction that was on this law. So now it is the law of the land. I'm going to go through the different sections, all of the different sections of the law. It may sound really, really boring. There may be some interesting circular arguments within this law. But when it comes right down to it, I think any physician who needs to know what he or she can do and can't do when it comes to the issue of abortion, you need to know why or why not. And the best way to do that is to go through the law and see what it actually says. Because just like with the Dobbs ruling and the Roe versus Wade ruling, a lot of things have been reported about this law that maybe aren't completely accurate because on its face, it sounds more restrictive than it actually is. And just housekeeping, I will use the term unborn child when I am describing this law because that is the terminology used by the legislature in the Human Life Protection Act. If you are someone who is passionate about whether or not a fetus is an unborn child or not, if you would prefer to hear fetus, just change that in your head as soon as I say unborn child. I'm doing it just to be consistent with the law, so there's no confusion about whether there's a difference between a fetus and an unborn child. So this is a very long definition of abortion, and I'm actually going to break it down. But before I break it down, I'm going to read it all, and then we'll go through it one by one. Just FYI, for this particular slide, you will see terms underlined. I underlined them because all of those terms also are defined within the Human Life Protection Act, and we're going to go through those definitions as well. Later on, I have some slides with some things underlined just for emphasis. So it's just this slide where you'll see everything that's underlined is also defined, and we'll go through those definitions. So according to the Human Life Protection Act, the use or prescription of any instrument, medicine, drug, or any other substance or device with the intent to terminate the pregnancy of a woman known to be pregnant, with knowledge that the termination by those means will with reasonable likelihood cause the death of the unborn child, is an abortion. The term does not include these activities if done with the intent to save the life or preserve the health of an unborn child, remove a dead unborn child, to deliver the unborn child prematurely to avoid a serious health risk to the unborn child's mother, or to preserve the health of her unborn child. The term does not include a procedure or act to terminate the pregnancy of a woman with an ectopic pregnancy, nor does it include the procedure or act to terminate the pregnancy of a woman when the unborn child has a lethal anomaly. Okay, if I didn't stumble over that definition too much, you probably heard some exceptions to abortion that are within that definition. And when this act was first passed in 2019, I think there were some news reports, particularly nationally, that said Alabama had passed the most restrictive abortion law in any state ever. And I think a lot of that had to do with reading specifically, without seeing the definition of abortion, reading the act that essentially says that the only exception is the medical emergency. But you'll see as we go through these, there are a lot more exceptions. Okay. The general definition, just let's not go through exceptions yet. The general definition, I've got that section and then basically a summary of what it means. The use or prescription of any instrument, medicine, drug, or any substance or device with the intent to terminate the pregnancy. So this tells us it includes surgical abortions and medical abortion. And by medical abortion, I mean the prescription of a drug like RU486. Those would be included within the definition of abortion in the Human Life Protection Act. But it's very important that the intent to terminate pregnancy is required. So if a medication that can be used for an abortion has another indication, you can still prescribe that medication or order that medication as long as it is not with the intent to terminate the pregnancy required. And I'll talk about that a little bit later when we get to some Q&A. Okay, and it has to be a woman known to be pregnant, and it has to be with knowledge that the termination by those means used will, with reasonable likelihood, cause the death of the unborn child. So not only has there got to be an intent to terminate the pregnancy, but there's a requirement that there's knowledge that the woman is pregnant, and the intent requires knowledge that whatever means or method used will likely cause the death of an unborn child. So once again, using that methodology or that means or method, and you're not intending to cause the death of the child, that technically is not the definition of abortion under the Human Life Protection Act. Now, still within the definition, you have exceptions. The term does not include activities such as saving the life or preserving the health of the unborn child, removing a dead unborn child. So if we're talking about a fetal demise situation and a D&C, that is not considered an abortion under the Human Life Protection Act. To deliver the unborn child prematurely to avoid serious health risk to the unborn child's mother. So if there's an attempt to deliver the child in order to save the life of the mother and the child dies, that is not an abortion according to the Human Life Protection Act. Preserve the health of the unborn child. If there is a premature delivery in order to preserve the health or life of the unborn child and the child dies, that is still not considered an abortion. So this reiterates the intent. There has to be an intent to cause the death of the unborn child for it to be an abortion. So as I said, something like a D&C following a miscarriage is not an abortion as defined by this law. Now, there are other exceptions listed in the definition. You saw it was a very long definition. The term does not include any kind of procedure to terminate a pregnancy if it's an ectopic pregnancy. And we'll go over the definition specifically of ectopic as well, because it's a little bit more inclusive than just ectopics. And nor does it include the procedure or act to terminate the pregnancy of a woman when the unborn child has a lethal anomaly. We're going to go over the definition of lethal anomaly. I think it's in the next slide. There's certainly been some controversy over that, and I'll talk about it when it comes to the next slide. But basically, if this child has been diagnosed with a lethal anomaly, the termination of the pregnancy is not considered an abortion. So ectopic pregnancies, that includes not just when the egg has been implanted or attached outside the uterus, but also when it has been implanted inside the cornu of the uterus. So those are together considered ectopic pregnancies for the purpose of this law, and they are also both not considered abortions. Now, lethal anomaly. You can read the definition probably faster than I can read it, but it says a condition from which an unborn child would die after birth or shortly thereafter or be stillborn. Now, most of the controversy that I've heard about this really comes in the form of, well, is there a list of conditions that are considered lethal anomaly? There is not a list anywhere in this law. I know that might cause some panic initially, but I will say as a lawyer, granted not a doctor, as a lawyer, if I was defending a physician who was accused of violating this law, but who terminated a pregnancy because in the physician's judgment, the child had been diagnosed with a lethal anomaly, I would rather there not be a list than there be a list and the lethal anomaly that in the physician's judgment would cause the child to die shortly after birth or be stillbirth was not on the list. So not having a list, while it might be a little bit scary from the standpoint of being a physician, it really leaves it in the judgment of the physician. And if you're thinking, what in the world does shortly thereafter mean as far as dying shortly thereafter birth? How long is that? That's where you got to use your judgment. You got to use your common sense. I mean, I think if your literature says that, somebody survived with this condition to be 6 years old, but, 75, 85% of births are going to die within, 2 weeks or 2 months, I think you got a pretty good case that this is a lethal anomaly. But if we're talking like most people live in their 20s with this condition, that's probably not going to be something that you're going to be able to prove was a lethal anomaly. So it is a judgment call, and I know that's scary, but from that standpoint, I would say documentation of all the circumstances of what the condition is going to be your friend. The next definition is medical emergency, and this one's going to be controversial too. We'll get to that, but it's basically in the reasonable medical judgment of a physician, the pregnant woman has a condition that so complicates her medical condition that her pregnancy has to be terminated to avoid a serious health risk. And that is also defined. That is a pretty complicated definition. We'll go over that in, I think it's the next slide. And we'll certainly come back to the medical emergency part. And a physician is the obvious, somebody who's licensed to practice medicine and surgery or osteopathic medicine and surgery, but it is in Alabama. So a physician does mean a physician that's licensed in Alabama. All right, here's the serious health risk to the unborn child's mother. I'm not going to read all of this because it would be ridiculous for me to read every bit of it and then break it down. So I'm going to break it down into parts. So you will get all of it. I just wanted you to see how long it is in this slide before we get to breaking it down. Okay, the general definition of a serious health risk. In a reasonable medical judgment of the physician, the child's mother has a condition that so complicates her medical condition and necessitates the termination of her pregnancy to avert her death or to avert serious risk of substantial physical impairment of a major bodily function. So that's not something that you automatically go, oh, I know exactly what that is. It's another thing like the lethal anomaly, where it's something left to the judgment of physicians. And this is another case where if you have a patient who you feel like has a condition that's either going to potentially cause her death if you don't terminate the pregnancy, or something that in this day and age you would automatically consider abortion, then that's probably going to fit this definition. It's just going to be something you need to document in the terms of, hey, this is could cause a substantial physical impairment to a major bodily function, whatever that function is. It could be any system that could definitely hamper this person's life in a substantial way. So there is an exception to that. And the exception is, hey, we're not going to include, mental illness or emotional condition as a serious health risk, a claim of that. So if a woman who is pregnant comes to you as a physician and says, if you don't terminate this pregnancy, I am so emotionally overwrought that I might harm myself or do something to harm, the child that I'm carrying. That in itself is not considered an exception or not considered a serious health risk. But you've probably heard, and maybe you haven't, maybe that's why you're at this webinar, you might have heard that Alabama does actually allow an exception for mental illness to fit in that serious health risk category. That's because there's an exception to that exception. If a woman comes to you and claims, I have this condition, it's a mental or emotional condition, I'm going to harm myself or harm my child if you don't terminate the pregnancy, that's not good enough. But if a psychiatrist who has been practicing for 3 years at least diagnoses a woman with a mental illness or condition and documents that that condition exists, and that in the psychiatrist's medical judgment that she could engage in conduct that could result in her death or the death of her unborn child, then an abortion is a possibility. That is not a violation of this law. So it basically comes down to, for a mental or emotional condition to meet the definition of serious health risk, there's got to be a diagnosis of serious mental illness. That diagnosis has got to be confirmed by a psychiatrist with 3 years clinical experience. And there's got to be a likelihood that the woman's conduct based on this condition could cause the death of her or her unborn child. So that mental illness exception does exist, but there are some hoops that need to be jumped through, and they do involve a psychiatrist making or confirming that diagnosis. Now, there's more to that exception, more steps that you have to go through. If the mental health diagnosis and likelihood of conduct is confirmed, termination may be performed, but it's got to be in a hospital, and it must be performed by an Alabama licensed physician with admitting privileges at the hospital where it's performed. And it's just speculation on my part, but my best guess as to why this part was added into that exception is the legislature did not want to provide a loophole for someone to open up an abortion center or an abortion clinic just for people who claim to have the mental illness and maybe have a psychiatrist on staff and run it similar to how you might hear people describe pill mills or something of that nature. So it's not really that much more of a hoop to jump through. With this law, it's going to have to be in a hospital that the abortion is performed anyway by a physician. So, but that is something that's added to that exception. Okay, couple of more definitions, and they are pretty important, at least for describing this law and how this law in Alabama works. As I mentioned before, I'm using the phrase unborn child rather than fetus or some other term to describe the product of the pregnancy. But the Human Life Protection Act does define unborn child and uses that term throughout, defining it as a human being, specifically including an unborn child in utero at any stage of development, regardless of viability. Now, the phrase in utero is very, very important here. There are some states, I believe, that will define the child as an unborn child at any stage of development from the point of fertilization. that causes some serious repercussions for IVF treatment. Because Alabama has put in utero in the definition of unborn child in the Human Life Protection Act, we feel like IVF treatment is not affected here because at a pre-implantation stage, an embryo is not considered an unborn child or person with respect to this law. So in the event that unused embryos are discarded, that would not be considered an abortion under this law. Now, the definition of woman is important just to show that there's no age distinction in Alabama's abortion law. A woman is defined as a female human being, whether or not she has reached the age of majority. So there are no exceptions for minors when it comes to this abortion law. Women, whether they are, regardless of their age, are treated the same when it comes to this law. Okay, I know that was a lot of definitions. Now we're going to go into what the actual prohibition or restriction on abortion is in Alabama under this act. It's pretty short compared to all the definitions. The prohibition itself just says it's unlawful for any person to intentionally perform or attempt to perform an abortion, except as provided for by subsection B, which we're going to cover in the next slide. But note that this doesn't say it is unlawful for any person to have an abortion. The prohibition in the Human Life Protection Act is just on those that would perform the abortions. It is not on a woman seeking an abortion. Now, the exception is basically, this is where things get a little bit circular and a little bit confusing, and I have no explanation as to why the legislature made this law this way. But the exception reads, an abortion shall be permitted if an attending physician licensed in Alabama determines that an abortion is necessary in order to prevent a serious health risk to the unborn child's mother. Okay. If you remember, when we talked about the definition of medical emergency, it was basically what I just read. The definition of medical emergency is the physician, in the physician's judgment, the woman that is pregnant has a condition that could potentially cause a serious health risk. That was the definition of medical emergency, and serious health risk, as we saw, was defined as a condition that could lead to death or a substantial impairment to a major bodily function if the pregnancy is not terminated. So the reason this gets confusing is right after that. Except in the case of a medical emergency as defined herein, the physician's determination of the serious health risk shall be confirmed in writing by a second physician licensed in Alabama, and that confirmation shall occur within 180 days after the abortion is completed. And it shall be prima facie evidence, which just means on its face, for a permitted abortion. Okay, the confusing part here is that the serious health risk and the medical emergency are essentially defined in the exact same way. And yet, the legislature is saying here that if you as a physician determine that a woman has a serious health risk, which means the pregnancy needs to be terminated, you have to get confirmation of that serious health risk from a second physician within 180 days of having the abortion, unless it's a medical emergency, which is defined in the same way as the serious health risk. So I was going to kind of save like some suggestions and risk management at the end, but I think from this point, the best advice I can give any physician who may find himself or herself in this situation with a patient that you think has a serious health risk and that pregnancy needs to be terminated. The good news is that confirmation from a second physician doesn't have to be before the abortion. It can be up to, I mean, we're talking like 6 months after the abortion. So if you find that you have a patient who is in this situation and you need to terminate the pregnancy, do your best, even if it's an emergency, a true emergency situation where you've got to go and you've got to terminate this pregnancy now, go ahead and try to get that confirmation from the second physician, regardless. You have a long time to get that information, get that documented in the record. And if for whatever reason you can't get that confirmation from the second physician, you still have a defense that what you did was within the exception in the statute and not a violation of the law, just by documenting what the emergent circumstances are, because you can still prove that it was hence a legal abortion within the exception by saying it was a medical emergency. I realize the definitions are the same, but your best, and I'll let Mallory confirm this because she's the risk manager, not me, but I think your best risk management in this situation is to try to get that confirmation. Okay, let's talk about if, unfortunately, you are on the wrong end of this law, what the consequences actually are. First, when it comes to liability, there are some immunity provisions in this law, believe it or not. One is what I've already mentioned. No woman upon whom an abortion is performed shall be criminally or civilly liable in any way. So there's no consequence to a woman seeking abortion or having abortion in Alabama, even with the restrictions on abortion. The consequences would be for the physician or party individual performing the abortion or attempting it. But also important, there is immunity for that second physician that confirms the serious health risk. So you got 6 months to get it. It doesn't have to be before the abortion. And the physician who confirms the serious health risk has immunity. So there are lots of reasons that if you are in that situation, you should be able to get that confirmation from the second physician in order to feel confident that no one can allege that you are in violation of this law for performing an abortion. Now, what you see on the screen in quotes actually come from the law. What I have added in bullets underneath is just generally what a Class A felony and a Class C felony means in Alabama when it comes to possible punishment. So an abortion performed in violation of the Human Life Protection Act is a Class A felony. That is, that's big time when it comes to imprisonment and when it comes to fines. Now, does that mean that if a physician or any individual is alleged to have violated this law and is convicted for it, that they're automatically going to go to prison for life and they're automatically going to have to pay a fine up to $60,000? No, I just included those because that is a range. If you are convicted of a Class A felony, you are looking at possible imprisonment from 10 years to life. You are looking at possible fines from $30,000 to $60,000. An attempted abortion is a Class C felony. That's not as strong when it comes to the actual potential punishment or violations, but still scary. A felony is going to be anything over a year and a day in prison and possible fines up to $15,000. So there are some serious consequences for someone who is caught violating this law. When it comes to medical emergencies, this is where things kind of, goes back to that circular argument. There is a specific law within the Act that says this chapter shall not apply to a physician licensed in Alabama performing a termination of a pregnancy or assisting in performing a termination due to a medical emergency as defined by this chapter. So that goes back to that circular argument I just gave you. It truly is helpful in that it reiterates that if for whatever reason you as a physician who have to terminate a pregnancy because of that serious health risk, if you can't get that confirming statement from another physician, or if you can't get it within the 180 days allowed, you still have a defense that the pregnancy termination was legal and not a violation of this law by proving, and you would do that with your documentation of the circumstances surrounding the termination of the pregnancy, by proving that it was due to a medical emergency. So that confirmation by a second physician is very important, but there is some leeway and some defense if for whatever reason you can't get it. Now, there is a section in the Act that deals with construction with other laws. That's because this was enacted before Roe versus Wade was overturned, and when Roe versus Wade essentially said that if you put too much restriction on abortion, or really any restriction, and especially in the when the child is not considered viable, then that's not going to be constitutional. So that's why you have this section in here. It basically says that this is going to nullify any Alabama law that is inconsistent with it, although you're not really going to find any Alabama laws that are inconsistent with it, because there are no Alabama laws that just specifically allow abortion. But it essentially says, if this chapter is challenged, that goes along with what I heard, that when the legislature enacted this law, they intended it to be challenged, maybe to overturn Roe versus Wade. That just didn't happen. But it basically says everything, the laws are going to go on as usual if this is challenged. It was challenged, and a federal court basically put an injunction in place while Roe versus Wade was still the law of the land. And so that's why you didn't hear anything about enforcement of this law. It could not be enforced. So this actual section, I included it here just so you'd know that you were getting all of the act, but it's not really important for the law as we go forward. Now, Alabama does have a lot of laws on the books with respect to abortion. And just to give you that information, I'm going to go through them briefly. Most of these were passed prior to the Human Life Protection Act. Gianna's law was not. It was the only one that came after the Human Life Protection Act. And to just briefly tell you, these are not less restrictive on abortion completely and more just put some minor restrictions on abortion or around abortion. Gianna's law was a law enacted that basically says if there was an attempt at an abortion and the child beat the odds and is born alive, this law requires any physician who is performing the abortion to make any efforts to preserve the life of the child if possible. The Alabama Unborn Child Protection from Dismemberment Abortion Act, which is a very long title, but it actually tells you exactly what it is in the title. It prohibited abortion by dismemberment. That is one of the restrictions that you could get away with Roe versus Wade, because it didn't make it an undue burden for a woman to get an abortion just to limit the method or type of abortion. Unborn Infants Dignity of Life Act, that prohibits the sale of body parts or other human remains as products of abortion. The Women's Health and Safety Act, that was a lot about the regulation of care at abortion centers. I mean, with the Human Life Protection Act, you pretty much don't have abortion centers anymore because you're not going to have enough medical emergencies basically abortions are going to have to be done in a hospital. Ectopic pregnancy, this was a law that was passed several years ago, and it would have been effective even if the Human Life Protection Act did not specifically exempt ectopic pregnancies from the definition of abortion. But it's good that the Human Life Protection Act did anyway. This law said the same thing as that exception in the Human Life Protection Act. Termination of ectopic pregnancies, including those in the cornu of the uterus, are considered exempt from the definition of abortion. When this law came out, it even said it was applicable to all other abortion laws. So there's extra protection that an ectopic pregnancy is not considered an abortion in Alabama. The federal abortion mandate opt-out was basically a law that the legislature passed, which it was required by state if the state did not want federal health plans paying for abortion. And the legislature determined that they did not want federal health plans paying for abortion in this state, and so that's why they passed this law. Alabama Pain-Capable Unborn Child Protection Act, that is something that's really moot now. It was a law that prohibited abortion before there was at least determination of post-fertilization age. I don't know if that law was actually ever enforced. I know that the Woman's Right to Know Act, that requires information to be provided to a woman seeking an abortion before it's performed, in the video and the printed material. As far as I know, the way that law reads, the state's still on the hook for printing that material, but it was primarily to be used in abortion clinics. There was an exception for facilities where abortions are not typically or usually performed. So I don't know that you'll see that requirement for that information to be given out now with the advent of the not needing abortion centers anymore. The Partial Birth Abortion Act, once again, very descriptive, prohibits partial birth abortion, abortion of a viable unborn child. This prohibits abortions when the determination of viability has been made. This was a direct action, I believe, after the Planned Parenthood versus Casey Supreme Court case, because that is the case that changed the trimester framework to a viability standard or framework. And so I guess Alabama wanted to make sure, hey, if there's been a determination that this pregnancy is viable, we don't want to have abortions here. And then the parental consent to performing an abortion on a minor, that once again is very self-descriptive. It requires parental consent for minors to get an abortion. Now here's the scary one, because this one, even though you'll see, because I included the history, this was first included in the Alabama Code in 1852. This is a law that was actually mentioned in the Dobbs opinion by the Supreme Court when talking about how many states had laws restricting abortion before Roe versus Wade. So this has been on the books in Alabama for a long time. I don't know if it was enforced prior to Roe versus Wade, but it certainly was not enforced after the Roe versus Wade opinion came out. It essentially says something similar to the Human Life Protection Act, but it's in the criminal code. It's basically a miscellaneous law in the criminal code. It says any person who willfully administers to any pregnant woman any drug or substance, or uses or employs any instrument or other means to induce an abortion, miscarriage, or premature delivery. Now, I've highlighted for emphasis the next part, or aids, abets, or prescribes for the same. The conviction shall be fined not less than $100, no more than $1,000, and could be imprisoned in the county jail or sentenced to hard labor for the county for not more than 12 months. That particular punishment drops this from a felony to a misdemeanor. But what's important about this law is that it does include a criminal penalty for someone who aids and abets a woman getting an abortion. The Human Life Protection Act makes no provision for anyone who aids or abets an abortion. It's only for someone who performs or attempts to perform an abortion. So the question has come up, I think, nationally and even in this state. Can a physician who maybe refers a patient to another state where abortion is legal to get an abortion, or who takes any steps, including funding or financing an abortion, are they possibly guilty of a violation of the Human Life Protection Act? I think there's an argument that they are not of the Human Life Protection Act because there's nothing in the Human Life Protection Act that specifically says anything about aiding or abetting the performance of an abortion, but this law does. And this law has not been federally enjoined. To my law, it's never been enforced. The Attorney General's office has been asked about this law and specifically about aiding and abetting. It's my understanding that there has been some communication to some healthcare insurers, essentially saying we consider any payment for an abortion to be a violation of the law in Alabama. I don't know if the reference is to the Human Life Protection Act or to this law, but the Attorney General has basically been pretty silent as to whether or not this is a law that will be enforced, that can be enforced. It is enough to where I would certainly say to any physician, you need to take a breath and take a pause before doing anything very specific that might be considered aiding or abetting an abortion. I think just talking to a patient about an abortion, certainly there's First Amendment rights available there. You have a First Amendment right to talk to a patient about anything. But I think any specific overt act, there is risk there. There is certainly concern that if not under the Human Life Protection Act, there's still an opportunity for prosecution under this law. And certainly we've made attempts to reach out to the Attorney General to get in a position on it and just haven't really gotten any kind of response. So unfortunately, we have to leave this with, it's a possibility and something the physicians in Alabama need to know about when it comes to the aiding or abetting. Now, I'll briefly go over some common questions and I'm going to turn things over to Mallory. This is something that we put out to our members just based on some common questions we've gotten about the abortion law since the Dobbs opinion came down. One was, will the termination of ectopic pregnancies be considered abortions under the Human Life Protection Act? And you should know by now, after the slides I've gone over, ectopic pregnancies have been specifically accepted from that definition. So the termination of an ectopic, not considered an abortion in Alabama, not a violation of Human Life Protection Act. Same with in vitro fertilization. Because that act defines an unborn child as in utero, we're not talking about pre-implanted embryos or the discarding of pre-implanted embryos as being involved in the Human Life Protection Act or the definition of abortion at all. We've gotten questions about whether exceptions for rape and incest are allowed. Well, I went through the entire act with you tonight, so I'm sure you wouldn't have missed any definitions for rape and incest. So there are absolutely no definitions no exceptions for that now. Whether or not any will be proposed, that's a possibility in the next legislative session. What the appetite of the legislature will be for adding those, I cannot say. I have no idea. But as of right now, there are no exceptions for rape and incest. What about contraceptive medications like Plan B? Well, the use of contraceptive medications are designed to prevent fertilization or attachment to the uterus, and they're not designed to, there's no intent to terminate a pregnancy. So if they do what they're supposed to do, and there's no intent to terminate a pregnancy by taking Plan B, it's just to prevent a pregnancy, then they should not be affected by the Human Life Protection Act. Drugs like RU-486, that's interesting because for RU-486, if prescribed with intent to terminate the pregnancy and terminate the life of the unborn child, that is absolutely a violation of the Human Life Protection Act. But I know that there are medications within RU-486 that can be used for other things. I have heard, or we have heard, that there have been some issues with the ordering of medications like Cytotec for non-abortion purposes and having trouble getting those medications from pharmacies because the pharmacy being concerned that they would be in violation of the act. I would say if that comes up in any situation where you as a physician need to prescribe one of these medications that could be used for an abortion, it's in your best interest to go ahead and put that indication of what you need it for on the script so that there's no confusion and you absolutely can get that medication to your patient when you need to. What is considered a medical emergency? Talked about that already. It's basically the physician's judgment that not terminating the pregnancy would either cause a serious health risk, which is either potential death or a substantial impairment to a major bodily function. That's the kind of thing where, number one, as a physician, if you're in that situation, you need to terminate the pregnancy. You absolutely need to document the consequences that could happen if the pregnancy was not terminated. You need to seek that confirmation from a second physician. You don't have to do it before the abortion is performed. And you also need to document any circumstances that would explain the emergent condition, just in case you have trouble getting that confirmation and you need to use the medical emergency as a defense where the confirmation is not necessary. D&C procedures for missed abortions. That's not with a reasonable likelihood that you're going to cause the death of the unborn child, because in a D&C situation, you're already looking at fetal demise. So that would not cause the death. That would not fall under the definition of abortion, and therefore D&C procedure would not be prohibited under the Human Life Protection Act. And as I just talked about, criminal penalties for assisting a pregnant woman to get an abortion where it is legal, meaning a referral or providing transportation, etc. As I've already mentioned, the Human Life Protection Act doesn't say anything about aiding or abetting, but we do have that law from the criminal code that does. So right now, that is a potential risk for physicians. I think that I would be very cautious as a physician to do anything overt that might be considered aiding or abetting an abortion. Here's my contact info. In case you don't, for whatever reason, get a question answered today and you want to reach out and talk about any issue, that's my office phone number and my email address. And I'm going to now introduce Mallory Earley. Mallory is a regional manager for risk management at ProAssurance. And I know for a fact that she has given a lot of talks on this issue. And, you know, ProAssurance insures not just in Alabama, but in other states. So she's probably going to have some great information for comparison purposes of what physicians in other states face, and maybe some questions that they have gotten at ProAssurance, maybe some risk suggestions too. Mallory and I worked together for a long time. She's an excellent lawyer and an excellent speaker. So I'm really happy that she was able to join our presentation. And I'm going to stop sharing my screen to allow Mallory to share hers, because I think that she has some slides as well.
All right. Well, thank you, Brandy. And I'm going to go ahead and share my screen just so we are all seeing the same thing. All right. So first, just wanted to give a quick kind of overview as to who I am and a little bit about how I kind of got into this role. So as Brandy mentioned, I'm a licensed attorney here in Alabama, but I'm employed with ProAssurance, which is one of the leading medical malpractice carriers here in Alabama. And we have received a number of questions in regards to these issues. And I first want to really commend the Medical Association for putting on this program and laying out the actual law that's in place in your state, because I think that's a piece that's missing from a number of educational platforms because they are so generic. And luckily tonight, you've been able to hear specifically what is going on in your state, what the expectations are, what the Human Life Protection Act really means, and gone through it line by line, piece by piece, to really understand what you're up against and where there are a few gray areas, as Brandy pointed out, but more importantly, to give you some guidance as you're continuing on with your practice. So I'm going to go over just a few of the medical professional liability implications tonight, going through a little bit about the resources. You know, obviously, as Brandy mentioned, ProAssurance is now a national company. We write in all 50 states. And so we anticipated through the leaking of the court opinions that there was going to potentially be a case that overturned Roe versus Wade. It was came out about spring of 2022. And then ultimately with the decision that was handed down on June 24th of this year, and with that Dobbs decision being now the current rule of the land, we wanted to make sure that we responded in a proactive way. And so we began every other week. We got together as a task force and got together with our claims department, underwriting, and marketing, along with risk, to really determine what are the issues our physicians are facing, how can we best respond and give them information without crossing into too many state-specific lines. So tonight's program is really the best of both worlds. If you have questions as to what is my insurance going to cover, hopefully we can cover a little bit of that, but more importantly, what are your specific state implications here in Alabama? And so I think that that's been a great way to look at it. So a number of the questions we received came through our risk management hotline and helpline, and some of you may be familiar with that if you're a ProAssurance insured, but we have a Monday through Friday, 8 to 5, a helpline that's available to physicians to call in and receive risk management advice, not legal advice, just risk management. And so that's where a number of these questions and issues came from. So because of that, I do want to make sure that we only cover, let me make sure I've got my disclaimer. There we go. All right, that the information that I go over tonight is based on sources obviously that are accurate at the time. With it being December 1st, 2022, it is accurate as of today. But as many of you know, this law has been ever changing and the legislation has been ever changing since the court opinion came down in June. We are seeing it from the standpoint of state legislatures, but then also post-election. There's been a few more states going through some additional changes. And so this law is very fluid, and as it it relates across the country. Here in Alabama, looks to be pretty set in at least temporary stone from what Brandy has put out there, but not something that we anticipate any major changes here in Alabama, but just to be cautious that some of the information could change as there's further legislation on this issue. This is obviously not going to be legal advice, although I'm a licensed attorney. This is going to be risk management advice. However, if we do have a physician who has an issue that is very patient specific and needs to be addressed by an attorney and is an insured of ProAssurance, we would put you in touch with our claims department, have those defense counsel assigned to your case, and those privileges would attach. And again, any slides that are distributed are meant to have an oral presentation going along with them, not meant to be used outside of that context. I want to go ahead and give you my contact information just in case there's a question that pops up and you have something specifically for me. I wanted to just put that on here from the outset. So here's my phone number, email address. Feel free to reach out. As Brady mentioned, I'm the Southeast Regional Manager, and then also am still covering some of the Southwest, which is where some of my case examples will come from, because Texas is very, very different and very much a wild, wild west kind of state. So how does this impact and who does this impact? And I think that's really the part that we've focused on here at ProAssurance, is that the restrictions that are being put on physicians, regardless of where they are, really comes down to, are they treating a patient who could become, or is currently pregnant? And that's really a significant amount of the population. I mean, this impacts female population in childbearing years. I mean, gosh, it's really runs the gamut, much more than just the traditional OBGYNs might be faced with this, maybe a emergency room department physician, but we're seeing questions that come from literally all specialties. And we'll go through some of those examples, but it's been interesting to me to see how there's almost an air of fearfulness about how to proceed with maternal care. And that's something that we are very cognizant of, and here is a resource should those questions arise. Now, I do want to make sure that it's clear that for the most part, medical professional liability is not going to shield a physician from any type of liability for illegal acts. You know, those are typically not going to be insurable. If you are in violation of a state law, whether it's in Alabama where you're practicing or any of our physicians in other states, if there's a violation of an illegal act, it's likely not going to be insurable. Now, you will hear part of the news recently has been that insurance carriers are looking into alternative types of coverage, things such as, you know, should I be named, you know, in a criminal suit, I want insurance to cover my defense costs for a criminal liability suit, things of that nature. So it gets a little bit tricky, and I think insurance is responding in some unique ways, more so in the Pacific Northwest, where there's a bit more frequency of abortions and things of that nature. But to be clear, that is not a part of ProAssurance's current policy for our insurers, especially not here in Alabama. We don't anticipate it, but should the need arise, it is something that is on the horizon for some other carriers. I think part of it, just as Brandy mentioned in the Human Life Protection Act, is it's difficult because there's not necessarily a definition in any state that I've seen for a true, clear, what is a medical emergency? At what point is something to that extent where there might be different interventions available to a physician? And that's been something that we've struggled with from risk management because we often give gray answers. And this is, again, one of those areas where medical emergencies are typically tough to define. And we don't necessarily want those parameters defined because it can honestly back a lot of our physicians into a potential corner that can be more difficult from a defense standpoint. So although it's difficult, we actually appreciate the fact that there is a gray area for medical emergencies, because ultimately, without them clearly being defined, we have a little bit more flexibility should they arise as a potential defense for a physician. We're seeing a few areas of impact that I did not anticipate, as I previously mentioned, across the country in regards to residency programs and medical school training, because we're seeing that recruitment efforts are impacted based on these state variations. We're seeing that especially in states such as Texas, where there's maybe a significant medical school program. They're wanting to recruit new doctors to their area, but there are limitations as to the abortion laws that are in the state of Texas. They're some of the most strict in the country, and that training is not going to be available to some of the residents. And so that's difficult because physicians are not necessarily going to be prepared practice across the country, because abortions, even from the standpoint of teaching aspect, are not going to be readily available to be performed there. So as I mentioned, it's something where we're seeing this start creeping into areas that were maybe not anticipated in a number of state legislations. Now, also, we're seeing that doctors are beginning to second guess some of their medical training and expertise when it comes to choosing a treatment plan. They're concerned about, in some states, risking a felony or a criminal conviction for performing an abortion. And now doctors are involving the hospital systems. They're involving lawyers. They're involving people like me, risk managers, to weigh in on life and death scenarios that we weren't necessarily equipped to handle. I mean, these are situations where you want a doctor calling the shots for medical decision making, but post-Roe and in this Dobbs era, we're starting to see some fear and questioning, and that's makes all of us a little bit more uncomfortable. So situations like this webinar are great to really set out what the expectations are, what the laws are here in Alabama for you providing these types of services should you be faced with that decision, and hopefully gives you some confidence in your decision making and medical judgment. Obviously, there are some situations in some states where there truly is possible criminal liability. As Brandy mentioned, it's fairly limited here in Alabama, but other states are not quite as forgiving as Alabama, as you can imagine. It really runs the gamut from some being very, very open to not even just physicians performing abortions, but nurse midwives, mid-level providers, PAs, nurse practitioners. I mean, really, there's certain states, Delaware being one of them, with almost lets just about any medical professional provide these abortion services because it's a state where it's much more liberal. Then you've got on the flip side, obviously states such as Tennessee, which is even more so conservative and rather strictly conservative based on their limitations of their state law that doesn't even allow an abortion in an ectopic pregnancy situation. And that's one that's very controversial. They're one of the only states that does not have that listed. So here in Alabama, you're really middle of the road. And it's good to see that there are some situations where you can feel confident in your medical decision making to go forward with what you feel like in your professional judgment is appropriate. So really, when it boils down to it from a risk management standpoint, it's always going to come down to documentation and communication. And those are going to be the two issues and two areas that we harp on for the most, because ultimately thorough documentation of showing what the present condition is in front of you, the conversations you've had with your patient, the reasoning behind why you went with the decision you went with, really have to be included in that medical record, and not just with the patient, but when you're having a pregnancy scenario, there might be another partner, such as a husband or a boyfriend, who's involved and wanting to weigh in on it and wanting to be a part of that decision making. And so really making sure there's open communication with the patient, anyone who is also appropriate in that decision-making conversation, but then really reiterating that importance of documentation, because at the end of the day, that's what's going to be called into question from a defense standpoint when it comes to a medical professional liability incident. So I want to go through just a few of the examples that we've had from our risk management call line and risk management phone calls. And again, these are not all from the state of Alabama, but I will point out the state in which they are from to give you a little bit of perspective as to what types of things we're seeing here at ProAssurance in the risk management department. I do caution you that pretty much any of these phone calls could take about a half hour to an hour's worth of education. So I will try to keep it brief and just state the facts as to how they were presented to our department. But it just gives you an idea as to the emails, the phone calls, and those helpline issues we're seeing. So first, as Brandy mentioned, the prescribing concerns is one that we have gotten a number of calls on, but specifically one came from an Alabama gastroenterologist. And I actually took this call on our risk management hotline. She was a great physician and said, hey, I've got some concerns. I realized, with this decision, with Dobbs now being the ruling that's in place and the Human Life Protection Act here in Alabama being what's the kind of standard for abortions, I'm actually prescribing Cytotec, which can be used to induce labor. It's one of the two pills used for the medical abortion pill. And I'm prescribing it for refractory constipation. It's kind of a last resort. When nothing else has worked, this is kind of the last course of action I can recommend for a patient. And she's concerned because she was giving patients a full supply, meaning 30 days, 60 days supply of this medication, where there might be a minimal dose daily, but at one time there was enough to meet the standard of an abortion pill portion of Cytotec. And so her concern was she was prescribing this to female patients. And so what should she do? Should she stop prescribing? How should she handle this? And so our risk management advice was really more from the standpoint of how many female patients are you currently prescribing Cytotec for? And at that point, she only had a couple. It was 2. And I said, look, let's take a look and see what are their age ranges. Are they, in childbearing years? What's the situation? And it turned out that currently at that time, one of the patients was of childbearing years, but had had a hysterectomy. So she felt pretty confident that that was okay to be prescribing the Cytotec for that patient. Another was post-childbearing years and to a situation where it wasn't necessarily going to be a concern for an abortion. But she said, what happens when a patient comes in who's maybe in their 30s or 40s and is female and could possibly be able to have a child, and I still feel like this is a viable option of prescribing for refractory constipation. And we walked through the options and really kind of boiled down to, again, those informed consent discussions and documentation of what this looks like, having a discussion with the patient that they are unable to get pregnant and what type of birth control are they going to be using, almost going to the extent of, having pregnancy tests prior to prescribing, possibly even during the prescribing process, having at least 2 forms of birth control for the patient, things of that nature, similar to how dermatologists often do that for Accutane prescriptions. There's ways to still prescribe even when there's known potential lethal anomalies for an unborn child or unborn fetus. And so making sure that you're taking proactive measures. Again, as Brandy mentioned, there's been a little bit of pushback from pharmacies in filling those prescriptions because they're scared. They don't necessarily want the liability of filling a prescription and handing it over to a patient and concerned that they might be using it for an abortion pill. And so seeing that, having those relationships where a physician is comfortable calling the pharmacy and saying, this is not for an abortion. This is for XYZ, and this is the reason for prescribing it and why we need it. So something that was an interesting standpoint, because I really did not anticipate, after seeing the Dobbs decision come down, that a gastroenterologist practice could possibly be affected. And so it really opened my eyes, and it was very much surprising to me that was one of the questions we received fairly early on. We also received a number of questions on ectopic pregnancies, as you can imagine. Again, this is going to vary a good bit state to state, but ultimately boils down to the treatment and relying on the medicine and what is the standard of care in your state, what is appropriate, what would be, how do you determine and first diagnose an ectopic pregnancy, how do you confirm it, how do you put it in the record, and then what would be that treatment option for inducing that abortion. And really, again, that stressing the importance of documentation and the need for the procedure is really our best takeaways. Again, most states have that exception. For those that are in Tennessee, it's much more difficult, because that again is could potentially be used against a physician should they have a patient with an ectopic pregnancy. It is not a known exception to their statute, and they ultimately run the risk of criminal liability if they pursued an abortion again with a patient with an ectopic. And so it calls into question some issues with self-incrimination and some of the criminal aspect of it. It's a very difficult state. I anticipate there'll be some legislation and court cases battled out in the state of Tennessee, but luckily here in Alabama, that doesn't sound to be like an issue that you're going to be faced with anytime soon. We have had a couple of heightened requests from physicians. They're increasing the number of requests that physicians are receiving for surgical interventions. And actually, one was a practice here in Alabama that was getting an increase in the number of young childbearing year females, actually in their late teens, early 20s, asking for hysterectomies. So you're seeing a slight increase of women wanting that with their obstetricians. And obviously, there's a number of issues that comes along with that. First, insurance being one of them, and whether it's medically indicated, a significant major surgery that comes with a lot more risks than anything, but it's a misinformation from the standpoint of patients feeling like they would rather have a hysterectomy than run the risk of getting pregnant and needing an abortion. It was rather mind-boggling to hear, but that's truly sometimes what patients are hearing, thinking, reading on social media. And so making sure you have that proper education with patients, discussion with patients, and really making sure that this is not something that's typically going to be medically indicated. On the flip side, we've seen up in Indiana, there's an increase in a urology practice for vasectomies on male patients. A little bit different just because it's less invasive, but again, in that same vein, you want to be cautious as to any type of surgical intervention that may not be medically indicated. Be cautious about going forward with that. Now, I've also seen some questions in regards to harm to a fetus when advising treatment plan, and that comes in a couple of different scenarios, whether it's for pain management and opioid use disorder. There obviously is that risk of suicide from tapering down meds, and that's something that Brandy obviously mentioned a bit with that exclusion and a little bit of a carve out in the Alabama statute. But there's also the exception that we heard of in Virginia from a radiation oncologist that had a newly pregnant patient and had the ability previously to abort immediately and start treatment, or delay the treatment until after the baby's born. And really, how do you advise the patient of that? You know, here in Alabama, what would the options be, and how would you go about that? And it really, again, comes down to those options, not necessarily off the table, but I think they can be a part of a discussion, you know, as to what type of cancer is this patient dealing with, what are the indications for, survival rates, and what type of life and condition would the mother be in by waiting versus, potentially having an abortion and starting treatment immediately. So what does the prognosis look like? And ultimately, many of these decisions are going to come down to the patient. Although they want the medical opinions and you weighing in and having that ability to have that good communication with your patients, a number of these decisions will ultimately rest with the patient. And here in Alabama, there is no criminal liability or any type of liability imposed on the female who seeks an abortion. So I think that's something to keep in the back of our minds. We're also seeing a little bit of implications for fertility clinics. Again, not necessarily here in Alabama based on the definition, where fertility clinics aren't going to be necessarily as impacted as other states. But I did receive a rather interesting question, and I will share this one because it is out of the state of Texas, but it involves a fertility clinic where a patient was 42 and she wanted to partake in fertility. She ultimately had 3 viable embryos that had cleared their genetic testing and had been deemed good, 2 female, 1 male. The doctor used an outside lab for the embryo storage, and the patient comes back and decides to implant the male embryo. And they begin testing once she's pregnant at about 8 weeks or so, showed that there were hundreds of abnormal chromosomal defects, and ultimately the fetus was not going to be viable. However, in Texas, the state law is really at heartbeat. And so once she had an ultrasound showing confirmed heartbeat at 8 weeks, she was past the point of being able to seek an abortion in Texas. But the patient chose that she wanted to have an abortion. She's not able to, obviously, in Texas. And so she's starting to look into states as to where she could go. And that's in the patient's right. However, she asked for a refund from the fertility clinic and said, you told me these embryos were clear and good. They weren't. That's the only reason I'm having to have this abortion. I want my money back. And so the physician called us in risk management and kind of said, what should I do? And our first instinct, which rightfully so, said you're going to need personal counsel and you're going to need to involve an attorney, because there's fear that, especially in a state like Texas, any type of refund could be seen as aiding and abetting, as Brandy mentioned. That it's a part of it. The statute, one of the criminal statutes here in Alabama, but not in the Human Life Protection Act. But something to be thoughtful of, that could there be any type of settlement funds could be used or it's deemed as aiding and abetting, and open the physician up to further criminal liability. So that's something where at that point it was outside the scope of risk management and even outside the scope of medical professional liability, and we referred her to obtain her own personal counsel. We've started to see a little bit of impact of abortion on telemedicine, and I think it really comes down to where the physicians are located, where they're licensed. Are they licensed in one state, two states? You know, what types of impacts? You know, certain states have bans on any type of prescribing of abortion pills via telemedicine, things like that. It's really kind of determines where the patient's located, where the physician's licensed. But I think that's something that we'll see a rise in regulatory feedback from that. So, you know, there's going to be some limitations put on it, I assume, because that could have implications for both the patient and possibly the physician. Already touched on briefly the pharmacy pushback, you know, as to the pharmacy refusing to fill prescriptions, because you know, ultimately it obviously not necessarily here in Alabama, but in some states where it's a bit more, where it is legal and abortions are much more common, there is a potential argument that there is some discrimination possibly on basis of sex if the state law possibly bans certain drugs outright or as a means to induce abortion, but then the failure to fill that prescription may violate some federal laws. So depending on how those state laws impact and conflict with federal law, you know, it could take years again for it to sort out in the court system, which I think is ultimately a theme in a number of states. Right now, we're even dealing with that between Texas and Idaho when it comes down to EMTALA, and you know, there's basically two federal court cases on opposing sides right now. One in Texas saying the Texas law is going to trump the federal EMTALA law for any type of emergency stabilizing treatment in Texas, and really Texas should trump it. Whether that stands, we'll wait to see. Idaho, on the flip side, has where, you know, EMTALA should stand, and if their emergency stabilizing treatment is an abortion, it should be allowed. So we'll see how that one shakes out. It is still going to be determined. But one more, the last one to wrap up on some frequent calls that we got. This one was interesting and not something I anticipated. It did not come from Alabama. It actually came from a Midwestern state, but a patient had an abortion previously, and she wanted the physician to change her medical record, destroy her medical record, basically get it out of there that she ever had an abortion. And so it really keeps in mind from a risk management standpoint, making sure that you are in line with your destruction of medical records. In her situation specifically, the record was past due for destruction, but it was a little bit difficult to recommend that because they hadn't been falling in line with their destruction policy. But, you know, in this case, it is something to think about your retention policies and how to handle that if a patient was in some way had an abortion and then no longer wanted that to potentially be reproduced to other providers. So an interesting standpoint on that the patient asked for her records to be destroyed. So keep that in mind as well. If that is an option, there is some level of stigma associated with it. Even if there's not any implications from a state standpoint, there could be, you know, patients who truly don't want that to be a part of their medical records. So those are just a few of our most recent questions. I will stop there and I will stop sharing because I'm sure there's probably some questions for us to cover, but that was just kind of a broad overview of what we're dealing with from a carrier perspective and the types of issues we're seeing across the country.
Thanks, Mallory. We did have 3 questions, and I'll go over them really quickly because I think the way that we have this format set, I'm not sure if the attendees can see the questions. So I'll go through them. First was just a comment. I think there was some concern that when I described Roe versus Wade, going through the history of it, that I was possibly being a little political, and I apologize for that. Unfortunately, with the Supreme Court being involved in the issue of abortion, it's hard to keep out of the politics. My intent was just to reflect the Supreme Court's ruling and not to pick a side, so to speak. So I certainly apologize if there was any thought that there was political intent there, because as I said in the beginning of this presentation, we only want to present the law and the law as it will be enforced now that we know, or how we know it will be enforced now, nothing about whether one side or another is right or wrong. Another question was about whether or not the Alabama Attorney General has given any guidance on how the law will be informed, and specifically guidance with specific case examples. Unfortunately, I've not seen anything of that nature, and I don't even know if we should expect anything of that nature. Unfortunately, as I mentioned in the last question, it's hard to separate the politics from this issue. And there are always going to be political concerns, and any political officer that is set up to enforce something like this is probably going to shy away about being very, very specific on how or what the expectation is about how it's going to be enforced. Plus, you could have, a DA in a particular district or county, maybe want to do things a little differently, and there may be some discretion there. So I've not seen any guidance on that. Mallory, I'm assuming you haven't either.
No.
So unfortunately, we don't have that. That's why we wanted to do something like this, to just at least give you all an idea of what the law is and what we can feel confident about and what we're not sure about. And then the last question I do think is interesting. I will not repeat this attendee's name because I don't know if he intended this to be confidential, but this is one of our attendees who was in a lawsuit, a malpractice lawsuit, after terminating an ectopic pregnancy that the plaintiff later claimed was viable. And it sounds like this attendee had a very difficult time going through this process of malpractice and eventually won, which is good. And then there was kind of a comment of, if I'd lost this case, so some hotshot DA could have gotten me for 10 years to life. I think that that's great that you asked the question to this attendee, because it is important to note there is a distinction between malpractice and this Human Life Protection Act, because Human Life Protection Act is generally criminal. It may not be in the criminal code, but it is criminal because the penalties for violation are criminal penalties. So yeah, it would be a DA, and it would be a different standard than the standard of reasonable care that you would see in a malpractice case. So losing one, if say this act was in effect at the time of that malpractice trial, losing one would not automatically be a guarantee of losing the other. And in the same vein, unfortunately, winning one would not be automatically mean that you would win the other. So just note that the Human Life Protection Act is criminal in nature. So it's not the same thing. And technically, I think it is possible that if a physician was perhaps attempted an abortion because there was a serious health risk to the mother and things did not go well, there could be a possibility of facing an allegation of violation of the Human Life Protection Act and a malpractice case. So that documentation that I mentioned and Mallory certainly talked about is going to be super vitally important, and particularly that confirmation from that second physician. Because if you have that confirmation from that second physician from the Human Life Protection Act, it's going to be very, very, very difficult for anybody to say that you did something that you shouldn't have done. From a malpractice standpoint, that is unfortunately, it's a different standard. And I'll kind of let Mallory speak to that a little bit, just because that's what ProAssurance does.
Right. It's going to be much more of that, standard of care, reasonableness, reasonable patient standard, and going to be under the guidelines of other practicing physicians in your area under similarly situated circumstances, and really having that same causation. I mean, ultimately, there's pretty clear indication if there's an ectopic pregnancy, but should there be question of that, I think exactly as Brandy said, having that confirmation, regardless of the Human Life Protection Act and threat of potential criminality, is absolutely important. If there is any question about what the medical treatment and going forward is, having that confirmation by another physician is appropriate. And I do want to mention that not every state has that immunity that goes along with it. There are other states that you have to have confirmation from other providers where there's not necessarily immunity that goes with it, meaning that if you are the confirming provider saying, yes, that's what I would have done as well, you cannot be prosecuted here in the state of Alabama. And so that is an added protection that is in place to help and give that initial provider some recourse and feeling that they are justified in their decision making. Looks like there's a couple more questions, Brandy, that have just come in.
One is specifically asked about the medical association, so I'll at least address that one. The question is the medical association utilizing legal measures to restore access to this life-saving health care in accordance with practice and ethics guidelines from the WHO, AMA, and ACOG? Unfortunately, that's going to go directly to policy, and that's not what we were about tonight. So I'm not going to be able to address that question, but thank you for asking the question. And then the last question is, if there's an ectopic, do we need two physicians to approve? Under the Human Life Protection Act, an ectopic is not an abortion. So you do not need a second physician to confirm that it's an ectopic pregnancy. And I think that's all we have, unless there's another one coming in. It looks like that's, Mallory, I'm sorry, I didn't want to just answer that for you. Did you have anything to add to that?
The same way. I think the only caveat is, I know that we kind of just recently mentioned, there was a situation where there's a question as the ectopic. And I think that it depends if that ectopic is clearly one, or if there is any room for doubt or question or something of that nature, where when in doubt, I think that having some other consultation is appropriate, but by no means required.
Yeah, I think that makes a lot of sense. If there's any concern about the diagnosis itself, then it wouldn't hurt to get that second physician to confirm, because the second physician is going to basically be confirming that it's a serious health risk, which an ectopic pregnancy would or could be. So I think that that's appropriate if there's any issue as to whether or not it's truly an ectopic pregnancy. All right, I don't see any more questions, and I don't think I have any more closing comments because I spent most of the time talking. I don't know, Mallory, if you have any other issues to bring up.
No, I think it's just a matter of, I know that after all of this, it's probably about clear as mud, which is pretty much how we all feel about it. But hopefully this gave some clarity as to what you're dealing with here specifically in Alabama. And I don't know that you'll get much better than the overview that Brandy gave. I think that was fantastic for those of you practicing here. And, I really commend the association for putting this program on, and want to say thank you for our appreciation and asking us to participate. And on behalf of ProAssurance, we're here for those of you that may need us from the standpoint of medical professional liability insurance. So feel free to reach out.
All right. Well, thank you all very much, those of you who attended. And I do want to say, I do think that we got Dr. Booth eventually on the line, but for some reason we did not have her in the panelist capacity. So she was only on as an attendee. So I'm very sorry that you did not get to hear from her tonight, but we thank you. Any of you who attended, thanks so much to Mallory, who presented a great talk regarding what all ProAssurance has seen. And like Mallory said, any further questions, we've provided our contact information. We hope that you'll follow up. So thanks, everybody. I hope you all have a wonderful night.
Thanks.